turn now to the protective grandmother murder trial in Nevada. A retired homicide detective provided some interesting testimony yesterday on what he observed about the shooting that left Sean Babbit dead. Now, on direct examination, he said that Babbit appeared to have defensive wounds on his hands. The witness even told the jury what he believed was the motive.
I went up to the threshold of the door, peeked in, looked around. I wanted to have an idea at least of what had happened before leaving.
And what did you observe?
I observed the body of Sean Babbit on the ground, on his back, no shoes on his feet, multiple gunshot wounds on his body, on his hands, and blood pooling underneath his body.
What, if anything, did you observe about his hands?
He appeared to have gunshot wounds on some of his fingers and this part of his hand.
And would those be consistent with defensive wounds, trying to kind of protect yourself?
I would call them defense wounds, yes.
Now, you left your colleagues at the scene and you went to the headquarters where Ms. Bordeaux was taken, correct?
Correct.
And at headquarters, photographs were taken of her and a buccal swab was taken of her.
Correct.
And the jurors have heard about a buccal swab, but one was taken of Ms. Bordeaux, correct?
Correct.
Showing you what's been marked as case exhibit 137. You recognize the person depicted in that photograph?
Yes, that's the defendant.
Okay, and of course, same woman that is here today, correct?
Correct.
Okay. State's exhibit 138. Another picture of Ms. Bordeaux.
Yes, that's a closer shot of her face in that.
Okay. And this is hours after the incident, fair?
Yes.
Okay. You would agree with me that there are no marks, there's no blood, there's no scrapes or scratches to her face or neck?
No.
State's exhibit 139. Ms. Bordeaux from the side?
Yes, that's her right side.
140 from the back?
Yes.
And 141 from the other side?
Yes, correct.
Any blood, biological materials, tissue, skull, brain matter, anything on her shirt, front, back, or sides?
No.
State's exhibit 142. Ms. Bordeaux's top of her hands?
Yes.
Any questions, any scrapes, any blood, any defects in her fingernails, anything that you observe on Ms. Bordeaux's hands?
No.
143, the bottom side of Ms. Bordeaux's hands, anything that you observe there?
No.
No cuts, no scrapes, nothing.
No injuries.
When Ms. Bordeaux was at headquarters, did you also take a pair of handcuffs off of her person?
Yes.
Okay, State's exhibit 143, are those handcuffs?
Yes.
And did you also take a holster off of her person?
Yes.
State's exhibit 153, is that her holster?
Yes.
And 154, defendant's holster.
That's the back side.
While your colleagues are back at the scene, interviews are being taken place.
Correct.
And one person that was interviewed was Erica Babbit.
Correct.
Her husband, Chris Parnell,
Correct.
and a police officer who was friends with the defendant, but was also coincidentally on duty that day, Marcus Murphy.
Yes.
Based upon all three of those interviews and the call that you had from dispatch or the information that was relayed over dispatch, had you developed somewhat of a motive for this shooting?
Yes.
And what was that?
Based on the statements of the three, her daughter, her son-in-law, and her friend, it was very apparent that Mr. Babbit was attempting to gain additional custody of the child without supervision, and that caused a lot of anger and consternation.
Directing your attention to December 4th of 2019, did you learn about a life insurance policy?
Yes.
Tell us about that.
I was contacted by Sean's mother, who relayed information to me that there was a life insurance policy that they had not known about. She discovered as she was the executor of his estate. She informed me that persons had made attempts to put a claim on that policy. So
hearsay. Without telling us, thank you, without telling us kind of who made it, or I guess what Sean's mom told you, you found out that there was a life insurance policy, correct?
yes,
Did you investigate that?
yes,
And what was the company that the life insurance policy was through?
boy,
How much was it for?
$305,000.
And because the parties were divorced, did you learn there was no payout to Ms. Babbit? Well, let me ask you this. Who was the beneficiary of the policy?
The primary beneficiary was Erica Babbit, and the contingency beneficiary was Pamela Bordeaux.
And on what date was a claim made for that policy?
There was an attempt or an initial contact on 4/24 of 2019, 2 days after the incident.
All right, so coming up next, we're going to show you some of the cross-examination of this witness where the defense attorney challenges him on what he previously said about the victim putting on his shoes when he was shot to death. Keep it here on Court TV, your front row seat to justice.
I'm Matt Johnson in Dedham, Massachusetts for the killer or cover-up murder trial. This is Court TV, your front row seat to justice.
Welcome back to Court TV Live. I'm Michael Ayala. We continue our coverage in the protective grandmother murder trial going on in Nevada. Pamela Bordeaux, now she's accused of shooting and killing her ex-son-in-law, Sean Babbit, in April of 2019. Now, she claims it was self-defense. One witness, though, retired homicide detective Gary King, testified the victim had defensive wounds on direct examination. Now, on cross, the defense challenged him on those observations.
We reviewed in preparation for today any other records.
Yes,
And you review any medical findings that these were defensive wounds.
I don't know what the coroner called them.
Right. So if the court didn't call them defensive wounds, or would you disagree, or wasn't able to categorize them? I mean, are you suggesting that your experience puts you somewhere in a superior position as the coroner?
Based on what I saw at the scene of my experience, that their wounds to the hands are generally defensive, especially if
Generally defensive, I'm sorry?
generally defensive. If his hands would have been up and bullets are striking his fingers, I would expect to find bullets and defects in the walls behind him, which was not noted.
Okay. But again, you don't have any medical qualifications to make that assessment other than your experience.
No,
How long were you at the scene? You just 3 months, right? Before you went to go talk to them?
just long enough to get a lay of the land, see what happened.
Okay, does anyone ever contact you? I mean, there's nothing, Detective Bobby, Detective Long, who I guess is the second lead.
Detective Long was with me.
I was that's Long goes with you. Bobby takes at the scene. Catowich, I think you said.
Catowich and Hudson.
And
They would send me updates by text, but they
that's fine. And in terms of evidence collection, does anyone ever brief you on that? Did you kind of let them do their thing? Or?
when I got done doing what I needed to do at headquarters, we went back out to the scene and I received a full briefing on what Detective Hudson and I did. All right, sorry, it's TSA's and that.
Okay, and at that point, you never pushed the shoes either?
I don't recall if I noticed them there or not. We left.
Okay. In your affidavit, you discussed not only that he was putting his shoes on, right?
He was adjacent, in my opinion, to where his shoes were. I don't have no way of knowing if he was putting his shoes on.
Well, I mean, that's not what shot did. So it appears after that he may have been preparing to put his shoes on.
May have been prepared.
Okay, so adjacent to and may have been preparing. Let's see, there's a difference, right?
I didn't say that he was preparing as if he bent over and was attempting to get his shoes on. in my opinion, he was positioned where the shoes were as if he was preparing to put them on.
Okay. So you stated, verbatim, it appears the affect that Babbit may have been preparing to put his shoes on to leave. That's not a correct statement.
Yes, that's a correct statement. I said it appeared that he may be, not that he was putting his shoes on.
So you, as part of your investigation, you also took a look at the security divorce.
Yes.
Okay. You also, looks like you took a look at some financial records.
Yes.
Right, but you only said to me these parties were divorced at that point, 4 or 5 years, 4 years.
3 years, 3 to 4. I'm not sure the exact date of the divorce.
So you talked about counseling and Abbott, correct?
Correct.
That you only looked at bank records for about 3 months.
I didn't obtain a full year worth of records. I just thought 3 months would give us a kind of an idea if there was anything going on.
On marriage, that was 7 years.
I was worried about his financials, not so much.
I understand what you're worried about, but the counseling and all that. I mean, the counseling records had been ordered for, the counseling had been in place for how long?
I just asked for any and all counseling records.
Right, the building, you testified that he was paying for all of his counseling, correct?
I testified that there was recurring payments on the bank statements I had obtained to aid
For 3 months, right?
3 months, yes.
Okay, that's the scope of your testimony on that issue.
On the banking records, that's all I requested.
Now, the life insurance policy, you actually got did you get a policy then?
I received a policy from Hoya, I believe.
Okay. Now, you said it was a claim made 2 days before or after, right?
That's what I was told.
Okay, and that proved to be incorrect, right?
I have to review the documents.
Okay, so, let's show you, if you remember looking at them, it suggested that's the policy that was procured via your search warrant. We can keep that there, look at it, like.
Yes, this appears to be what they sent me.
Okay, the insurance is the very back of that policy. On the last page.
Last page.
Yes, sir. Who, do you know, find out who procured that policy?
What do you mean who procured it?
Who purchased the policy? Himself?
The proposed owner is Sean Babbit.
So that would have been him that, Mr. Babbit that did that?
Yes.
Okay, so not Ms. Bordeaux, right?
No,
Right, not Erica Babbit,
no.
right? And what was the date of that policy?
Date is 6/13/2014.
Okay, so it was 2014, they were divorced in 2016, correct?
Correct.
Okay, did you find as a result of your search warrant that he ever changed the beneficiaries?
No, not to my knowledge, not anything they provided.
Right, so to your knowledge, according to that, he left Erica and Pam as beneficiaries,
Yes,
even after the divorce,
yes,
for 5 years after.
apparently, yes.
Okay. Now, did you find that, let me just back that up a little bit. 2 days after, apparently when a claim would have been made, is Ms. Bordeaux in custody?
I don't know if she received bail or I don't know what that.
Okay, if I suggested you that she was in custody for several months after this, is your contention that a claim was made by her from jail? Is that
I don't know.
right? You don't have any information she made any claim, right?
No.
And that was incorrect, right?
I wouldn't say it's incorrect, that's what I was told.
Okay.
It was enough for me to follow up on.
So with the Ring doorbell that we talked about,
Yes,
and then there was a search warrant you applied for,
yes,
right? And again, in that application, we talked about the shoes and trying to put the shoes on, right?
yes,
Okay, and
period.
You only requested a few weeks worth of the ring, right?
Correct.
All right, let's bring in our guests for this hour. Joining me, criminal defense attorney Darnell Crossland and retired NYPD executive Corey Pegues. Gentlemen, great to see you. Thank you so much for joining me on this Friday. Darnell, I'll begin with you. I thought the defense scored some points there. That, you know, this idea of the insurance as motive, they pointed out it was the victim who actually took out the policy and that he seemed to never change the beneficiary because it was during their marriage and then 5 years later hadn't changed it. But there's also this question of possible defensive wounds on his hands. What do you make of those in terms of a self-defense case?
Oh, I think you have to point out whether, in fact, there are wounds that are sort of indicative of somebody trying to block either an oncoming blow or if somebody threw something at you, or even if they shot a gun and you're just trying to save yourself. So it's very important to point that out. But now obviously the other side is going to probably say that they're not defensive and they're going to try to put their case on. But it's classic 101. If you have certain marks in certain situations that are evidence of one trying to protect themselves, you have to point that out.
Well, if she's claiming he attacked her in some way, it's possible that it started out as an attack and she was acting in self-defense. Then once he realizes she's going to shoot him, starts backing up. Not sure they tell us that much, but I can tell you what might, Corey. I want to get your thoughts on this. This is a woman, the defendant is a military veteran. She's a retired detective in the Las Vegas Police Department. There were 10 shots in this case. Someone who's used to working with firearms, experienced with firearms. I think 10 shots says a lot. It says a lot if you're inexperienced with guns, but I think it says a whole lot, if you're experienced with it.
Oh, yeah. Good evening to both of you. Well, you know, police officers are trained to do 2 to 3 bursts. Boom, 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 check. Boom, 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 check. Not so that's a problem with just automatically firing. We're trained to do 2 to 3 fire bursts and then reevaluate the scene, because you know, after 2 or 3 fires, you should see where your bullets are going, or if you hit the person that you was trying to hit the target.
I would agree with you 100%, which is why if you're going to, you know, scrutinize her activities that day, one would say 10 shots probably means something more than maybe she was just trying to neutralize a threat. As a matter of fact, this detective that we saw testifying, he actually testified on redirect what he thought might have been going on in this case, and it doesn't sound like self-defense. Take a listen.
I knew throughout the investigation when 8 o'clock hit, it was done, you need to go. Based on the shot from the stairs and where that evidence was and the shell casing down around his shoes, I believe his first shot was fired. Well, she was on the stairs and he was at his shoes. His shoes were right there, his wallet, his iPhone, keys were right there. That's where he would naturally stop if he was preparing to leave.
It's a pretty decent supposition there, Darnell. What he's basically saying is 8 o'clock came around, it was time for him to leave. He was going to get ready to put his shoes on. He was by a table. His phone and his keys were on the table, getting ready to put his shoes on. Based on all the evidence, he thinks that's how it went down. He wasn't doing anything to attack her at all.
Yes, exactly. And it sounds that he's sort of articulating some distance. So if in fact she's claiming that she was being attacked, there will be a closer proximity. But if he's just putting his shoes on, ready to go, and she's shooting from the staircase, and shell casings are evidence of that, then that's going to go totally against her claim that she was under attack. It appears if there's distance between the two of them, that she could have retreated. So that's going to be damning evidence against her.
Yeah, no doubt. And Corey, at the end of the day, we don't know exactly what she's going to claim, right? We don't even know if she's going to take the stand. I think she has to take the stand in this type of case. There were only 2 people there. She's the only one that survived. But basically, we know what she told police. And she said this guy was a sexual deviant. He was addicted to porn. We also know that he wanted unsupervised visitation with the child that the 2 of them, her daughter, had with him. And I don't think grandma wanted that to happen. What do you make of that aspect of the case?
Yeah, and I agree. You know, these domestic violence cases are, you know, they could go any way. You never know. Let me get back to like the shell casing by his shoe. And you know, when you shoot the projectile, the shell casing is going to pop out and it should be going a couple of feet. It shouldn't be like right next to his shoe. If she was shooting him at point blank range, that shell casing should have popped out and it'd be, you know, maybe 3 to 4 feet away from his shoe. But as far as the visitation goes, you know that these things are so volatile all of the times. That's why it's so important and imperative for the judges to make really clear decisions on how these visitations go. But I've seen it so many times, how it could go left.
You know what, Darnell? As I said, I think she's got to get up there and tell her story. And so far, her story seems to suggest some sort of general threat to the child, to the family, not one that's specific. You can't get away with a general threat. This has to be specific, correct?
I agree 100%. So if you paint the picture that, you know, he's addicted to porn, he's a bad guy, all the jury's hearing is that I don't want that guy next to my grandchildren. They're not hearing that that guy is violent and that he was on this particular day acting in conformity with his violent nature, in that he attacked her, grabbed her, marks on her neck, etc. They don't want to just hear that you don't like him and that he's a bad influence for your grandchild. That doesn't give you the right to self-help and kill someone. So that's not going to fly.
Yeah, I think at the end of the day, this was a grandma who didn't want to leave it up to the courts as to whether this child would end up with unsupervised visitation with this guy, someone she considered a sexual deviant, and took matters into her own hands. That's what it sounds like at the end of the day, not self-defense. But we have to see. We don't know if she's taking the stand and what she will say.